Hi, welcome to Philippine Law and Jurisprudence channel. Um, we will now discuss persons and family relations. So we will start with uh, the Philippine legal system. It is basically an introduction to the Philippine legal system. Okay, so we will study the Philippine Civil Code. Okay, so the Philippine Civil Code consists of four books: persons and family relations, property ownership and its modifications, the different modes of acquiring ownership, and obligations and contracts. So we will basically discuss in this course the book on persons and family relations. Let us begin with effectivity of laws. Throughout your law school, you will basically and entirely deal with laws. So let me just walk you through the Philippine legal system, including the principles. So throughout your entire years in this university and after you become lawyers, will basically deal with two things: laws and jurisprudence. So laws, as we all know, consist of statutes, presidential decrees, executive issuances, rules and regulations coming from the different agencies of the government. Jurisprudence, as you all know, consists of decisions coming from the Supreme Court. So to walk you through the Philippine legal system, okay, let us begin with the effectivity of laws. When do laws take effect? Article 2 of the Civil Code specifically states that laws shall take effect after 15 days following the completion of their publication in the official gazette unless it is otherwise provided. So basically, the requirement for the effectivity of laws is its publication. So you need to publish the law before it becomes effective. An unpublished law does not become effective. Now, the question is, can you make it effective upon publication? Okay. Or can you make it effective not within 15 days, but let us say for a shorter period, like let us say 5 days? The answer is yes, because the Article 2 states that unless it is otherwise provided. So the phrase unless it is otherwise provided pertains to the date of effectivity. Publication is an absolute requirement. But the date when it should become effective is dependent on the legislature, meaning Congress. If Congress says that it is effective upon completion of the publication, they can do so, or they can even provide for a shorter period, such as 10 days or 5 days, depending on their discretion. Okay. So with respect to the Civil Code, the Philippine Civil Code, it took effect on August 30, 1950, or 1 year after its publication in the official gazette on August 30, 1949. Why? Because the Civil Code is a compilation. It is actually a codification of the different laws, okay, pertaining to uh, civil rights. Okay. Now, uh, let us go to the first case. Okay, Tanyada versus Tuber. Is there a need to publish presidential issuances where the date of effectivity is already provided? Okay, as I was saying a while ago, the Congress specifically has the discretion or power to determine the date of effectivity, but they have no discretion to dispense with publication. Okay, they cannot do away with publication. Why? Because of the main reason of due process. Okay, for laws to be effective, the public must be informed. They must be informed of what the law is. Otherwise, you cannot say that ignorance of the law excuses no one, especially if the laws are of general application, okay, and especially if the laws are penal in nature. Quoting Tanyada versus Tobera, the clear object of the provision is to give the general public adequate notice of the various laws which are to regulate their actions and conduct as citizens. Without such notice and publication, there would be no basis for the application of the maxim ignorantia legis non excusa. It would be the height of injustice to punish or otherwise burden a citizen for the transgression of a law which had no notice whatsoever, not even a constructive one. So it is the right of the people to be informed as well as their right to due process. Because if you would punish him for something which he does not know of in the first place, then that would be the height of injustice. So the publication of all presidential issuances of a public nature or of general applicability is mandated by law. Presidential decrees that provide for fines, forfeitures, or penalties for their violation impose a burden on the people, such as tax and revenue measures fall within the category. So presidential issuances of general application which have not been published shall have no force and effect. Okay. Now, Villafuerte versus Cordial speaks of the scope of the publication. What are the kinds of laws that are needed to be published? Does it refer to all laws? Or does it refer only to particular kinds of laws? So in this case, the issue is whether or not the non-publication of Resolution number 13/2013 divested the Sangguniang Panlalawigan of Camarines Sur of jurisdiction over the proceedings of the case. So what are the kinds of laws that need to be published? The court definitely expounded that law should refer to all laws. So when you speak of publication, that is a requirement for its effectivity. It refers to all laws. Thus, an indirect effect of a particular law to the public does not necessarily call for the dispensability of the publication requirement. All statutes, including those of local application and private laws, shall be published as a condition for their effectivity. So it doesn't mean that if the law is not of general application, such as if it is effective only for a particular city, municipality, or province, you need not publish it. So the publication requirement is a must, whether the law is of a local or a national application. However, the court clarified that interpretative regulations and those merely internal in nature, that is regulating only the personnel of the administrative agency and not the public, and letters of instruction issued by administrative superiors relative to the guidelines to be followed by their subordinates need not be published. So if it refers only to interpretative regulations, which is internal, or is to govern only the personnel of an administrative agency, then there is no requirement for publication. So in those cases, mere posting or dissemination of the said rules to the employees of the agency would be sufficient. So in this case, what was being assailed is Resolution number 13/2013, which provides for the rules of procedure concerning the conduct of investigation against municipal officials in the said province. So based on this resolution need not be published because it is only internal and it pertains only to the rules to be followed in the conduct of an investigation. So it is a procedural rule which is internal, okay, to the Sangguniang Panlalawigan. So there is no need for publication. So, but as a general rule, all laws, okay, whether of national or of local application, should be published as a requirement for its effectivity. Okay. Now the question resolved by the next case, which is nagkakaisang maralita ng Sitio Masigasig versus Military Shrine Service, is what if a part of a law or a portion of a law is not published or is omitted, okay, in the publication? What happens to that portion of the law? The answer of nagkakaisang maralita is that that portion of the law which was omitted in the publication does not attain effectivity or does not become effective. So this case involves a Presidential Proclamation number 2476, which amended Proclamation 423, relating to the portions or the parts of Taguig which are to be considered as open for disposition to the public. So in that proclamation, the late President Marcos made a handwritten addendum that states that this includes Western Bicutan. However, that handwritten addendum was omitted when it was published in the official gazette. Okay, so what happens to that portion of the addendum which was not published? Okay, the court said that publication is indispensable in every case, but Congress may in its discretion provide that the usual 15-day period shall be shortened or extended. Such omission, it is not correct to say that under the disputed clause, publication may be dispensed with altogether. The reason is that such omission would offend due process insofar as it would deny the public knowledge of the laws that they are supposed to be governed. So the term laws should refer to all laws and not only to those of general application. For strictly speaking, all laws relate to the people in general. So the Supreme Court further clarified the scope of the laws that need publication. It should refer to all laws. In fact, a law without any bearing on the public would be invalid as an intrusion of privacy or as class legislation or as an ultra vires act of Congress. To be valid, the law must invariably affect the public interest even if it might be directly applicable only to one individual or some of the people only and not to the public as a whole. Again, all statutes, including those of local application and private laws, shall be published as a condition for their effectivity, which shall begin 15 days after publication unless a different effectivity date is fixed by Congress. Administrative rules and regulations must also be published if their purpose is to enforce or implement existing law pursuant also to a valid delegation. So when Congress enacts a law requiring implementing rules and regulations from a certain administrative agency, that implementing rules and regulations must also be published to inform the public and as a requirement of due process. Accordingly, even the charter of a city must be published, notwithstanding that it is only of local application. Circulars issued by the Monetary Board must be published. Publication must be in full. So again, nagkakaisang maralita, the doctrine is the publication must be in full or it is no publication at all, since its purpose is to inform the public of the contents of the law. So this court cannot rely on a handwritten note that was not part of Proclamation number 2476 as published. Without publication, the note never had any legal force and effect. Okay, so Article 3 provides us the reason why there is a need for the publication of laws in order for it to be effective. Why? Because ignorance of the law excuses no one from compliance therewith. Once the law is published, any person is presumed to know the law. Okay? Applicability, it applies to all kinds of domestic laws, whether civil or penal, whether substantive or remedial. The rationale is expediency, policy, and necessity in order to prevent evasion of the law. Okay. What about foreign laws? Are you presumed to know the foreign law? If the foreign law is not properly alleged and proved, the presumption is that it is the same as our own law. So when we say ignorance of the law excuses no one from compliance, I am referring to Philippine laws. Okay? You are not presumed to know foreign laws. Foreign laws in our jurisdiction must be proved as a fact in accordance with the rules on evidence. Okay. Some illustrative cases for ignorance of the law, excuses no one, and processual presumption. As I have said, to reiterate, when we say ignorance of the law excuses no one and knowledge of laws, I am referring to domestic laws or Philippine laws. I'm not referring to foreign laws. Foreign laws must be proved as a fact. However, if foreign laws are not successfully proven, then the processual presumption applies. What is processual presumption? The presumption is that it is the same, the foreign law is the same as Philippine law. That was the doctrine in the case of Cuarto Cruz versus Active Works. So in this case, the petitioner was hired as a domestic helper in Hong Kong. And after a week, she was warned to improve her performance, and eventually she was fired. So she filed a case for illegal dismissal before the labor arbiter in the Philippines. So what law governs the petitioner's employment contract? Is it Hong Kong laws or Philippine law? So the Supreme Court applied processual presumption and said that the Philippine laws apply in this case. Why? Because the petitioner was not able to prove what the Hong Kong laws are. And considering that there is failure to prove the pertinent laws in Hong Kong relative to the contract of employment, it was held that it is the same as Philippine law. So the doctrine of processual presumption was applied. Okay, this is a case where processual presumption was also applied. The case of Rotterdam versus Glolax Enterprise. Okay, this case involves a misdelivery of goods in Panama, and as a result of which the respondent sued petitioner for damages. Again, the court laws prove themselves in our jurisdiction, and our courts are not authorized to take judicial notice of them. To prove a foreign law, the party invoking it must present a copy thereof and comply with sections 24 and 25, Rule 132 of the revised rules of court. So while the foreign law was properly pleaded in the case at bar, it was not proven in accordance with our rules of evidence. So it cannot be recognized. So if the foreign law cannot be recognized, then the processual presumption will automatically apply. Okay. So in relation to the publication requirement, okay, we also have the prospective application of laws. So you must remember that publication requirement is intended to inform the public that there is this law. And because there is this law, you have to abide or to comply with the said laws. And also in accordance with due process and in accordance with the elements of fair play, laws are supposed to apply prospectively. You cannot apply it retroactively unless the contrary is provided. That is what is provided for under Article 4 of the Civil Code. Why is it that laws are prospective and not retroactive? If the laws are retroactive, it would punish individuals for violations of laws not yet enacted. So it would be at the height of injustice to punish someone for an act which is not yet criminal when at the time when the same was committed. Okay? So there are, however, exceptions to the prospective application of laws. First is, of course, if the law themselves provide for its retroactivity. So if there is a provision in the law stating that this shall have retroactive application, then the laws may have retroactive application. If the laws are remedial in nature, when we say remedial, it is procedural. Why? Because there is no vested rights on procedural laws. Okay, if the statute is penal in nature, provided it is favorable to the accused. So if a later statute, provides a lighter penalty for an offense, then it may be given retroactive application. Fourth, if the law is curative. Why? Because the purpose of the law is precisely to cure errors or irregularities. That is the reason why it will be given retroactive application. And last, if substantive rights are declared for the first time, unless vested rights are impaired. Okay. We have the case of D Harvest versus D versus Harvest All Investment Limited. Okay. This is an illustration of an exception to the prospective application of the laws. Remember, again, laws are prospective in nature. Its application is from the time of the effectivity onwards. It cannot go back, unless you fall within the exception. So in this case, this involves a remedial measure. So it provides for an increase in the payment of filing fees. However, that payment of filing fees, that law which provides for that rule which provides for the payment of filing fees, came after the filing of the complaint. So the filing of the complaint was ahead of the law providing for an increase in the payment of filing fees. Can that rule be made to apply to the complaint which was filed ahead? At the time when the rule became effective, that complaint was already filed. So can it be made to apply retroactively? The answer is yes. Why? Because that is remedial or procedural in nature. The determination of the amount of filing fees to be paid is something which is remedial or procedural. And since there is no vested right in procedural rules, it can be made to apply retroactively. So the retroactive application of procedural laws is not violative of any right of a person who may feel that he is adversely affected, nor is the retroactive application of procedural statutes constitutionally objectionable. The reason is that as a general rule, no vested right may attach to nor arise from procedural laws. Now, compare the case of Harvest All to the case of Purata versus Philippine Ports Authority. The case of Purata involves an imposition of a different standard for determining the just compensation in expropriation cases. Okay, you know what an expropriation case is all about? It's all about eminent domain. So taking of property upon payment of just compensation. Okay, in this case, the issue is, may a law amending payment of initial just compensation to a landowner in expropriation cases be applied retroactively. So during the pendency of the case, okay, there is this law which provided for different standard of computing the just compensation. Can it be applied retroactively to cases which were already filed and is pending at the time when the law took effect? Okay, the answer is no. Why? Because the determination or of the standard of fixing just compensation is substantive in nature. It is not procedural. Okay, so in that case, considering that the law itself did not provide for its retroactivity, it should only be applied prospectively. So the old standard in the determination of just compensation would be the one to be applied in the case of Purak. Okay, again, borrowing the words of the Supreme Court, statutes are prospective and not retroactive in their operation. Laws being the formulation of rules for the future, not the past. The law provides for the future, the judge for the past. The reason for the rule is the tendency of retroactive legislation to be unjust and oppressive on account of its liability to unsettle vested rights or disturb the legal effect of prior transaction. A well-settled exception is when the law is remedial. However, in this case, the appropriate standard of just compensation is a substantive matter. It is well within the province of Congress to fix the standard, prescribe the new standards in determining the amount of just compensation in expropriation cases. In the application of RA 8974, the court finds no justification to depart from this rule. There is nothing in RA 8974 which provides that it should have retroactive effect. So the next case is Bilia versus CA. Okay, the case of Bilia versus CA is an illustration of how a law, a criminal law, okay, which is favorable to the accused was applied retroactively. So at the time when the accused was already serving sentence, a law was passed, okay, which decreases the penalty for the offense to which he is already serving sentence. And if you apply the lighter penalty, he would be deemed to have served his sentence. So can it be applied retroactively even if he was already convicted and is already serving his sentence? The answer is yes. Okay, why? Because it is favorable to the accused, provided further that the accused is not a habitual criminal. Okay, so Bilia versus CA illustrates for us what is meant by the exception to the prospective application of the law, which says that if it is criminal in nature and it is favorable to the accused, then the law can have retroactive application. Okay, we have the case of J.B. Angeles Construction versus NLRC. So in this case, we are speaking here of two laws, RA 7641, okay, which says that it can be applied retroactively, thus the law can apply to labor contracts still existing at the time that the statute has taken effect, and that its benefits can be reckoned not only from the date of the law's enactment, but retroactively. However, there are certain requirements that were imposed before the law could be applied retroactively. First, the claimant for retirement benefits was still the employee of the employer at the time that the statute took effect, and that the claimant has complied with the requirements for eligibility under the statute for such retirement benefits. However, in this case, even if the law itself provided for its retroactivity, the Supreme Court still held that it is not applicable to the private respondent. Why? Because Santos retired and ceased to be an employee of the petitioner 11 months before the law took effect, and he brought his complaint 9 months after the law's effectivity. So it is clear that the provisions of 7641 could not be given retroactive effect in his favor. Why? Because it is a requirement that the claimant for retirement benefits was still the employee of the employer at the time when the law took effect. So even if he filed the case after the law already took effect, it is required that he must still be an employee at the time when the law took effect. So even if the law itself provided for its retroactive application, it cannot be applied retroactively to the private response. Okay? The case of Poe versus Court of Appeals. Okay. The case of Poe, okay, illustrates to us that the prospective application of laws also applies to judicial decision. As you all know, as we will discuss a little later, judicial decisions are not laws. Okay? They are part of the legal system of the Philippines. And part of that legal system is the doctrine of stare decisis. So if you have a case with a certain set of facts decided by the Supreme Court, if you encounter another case having substantially the same set of facts, it will also be decided in accordance with the first case, which has substantial set of facts. Okay. Now, the doctrine of stare decisis or judicial decision also have prospective application. So it cannot be applied retroactively to cases which were already decided way back. Okay. So the case of Poe versus CA, in this case, there was a check. Now it was dishonored on the ground of closed account. Now Poe appealed to the Court of Appeals because at the time of the issuance of the check, okay, 4 years prior to the promulgation of the judgment in Ke versus People, in Ke, the Supreme Court stated that the delivery of a rubber or bouncing check as a guarantee for an obligation was not considered as a punishable offense. Okay, so he was invoking that the doctrine in the said case should apply to her also, because judicial decisions are to be applied prospectively and not retroactively. So the High Court said that the principle of prospectivity has also been applied to judicial decisions, which, although themselves not laws, are nevertheless evidence of what the law is. So a check issued merely to guarantee the performance of an obligation is covered by BP 22, should not be given retrospective effect to the prejudice of the petitioner and other persons similarly situated who rely on the official opinion of the Minister of Justice that such check did not fall within the scope of BP 22. Okay, so the next case is Villar versus People. Okay, in this case, the criminal acts alleged to have been committed sometime in 1993. However, another law was passed, RA 8042, on which the petitioner was charged. And it took effect on July 15, 1995. So the act was committed 1993. The RA 8042 was passed or took effect, became effective on July 15, 1995. So the petitioner should have been charged under the labor code and not under RA 8042. So the basic rule is that a criminal act is punishable under the law in force at the time of its commission. Petitioner can only be charged and found guilty under the Labor Code, which was enforced in 1993 when the act was committed. Penal laws, and which, while not penal in nature, nonetheless have provisions defining offenses and prescribing penalties for their violation, operate prospectively. RA 8042 amended pertinent provisions of the Labor Code and gave a new definition of the crime of illegal recruitment and provided for a higher penalty. So there is no indication in RA 8042 that said law, including the penalties, would take effect retroactively. So again, in criminal laws which are criminal in nature, especially, they only have prospective application unless, of course, the retroactive application of the law is favorable to them. So in this case, it is not favorable. Why? Because there is higher penalty for illegal recruitment in the new law as opposed to the old law. Okay, so being not favorable to the accused, it cannot be given retroactive application. So the case of Encarnacion versus Dynasty Amusement, okay, again, this is an exception to the general rule that laws apply only prospective. Why? Because the law is curative in nature. What do you mean by curative in nature? It is supposed to cure a defect in the past. So if you will not make it apply to the past, how could you cure the defect? Okay? So in this case, petitioner was employed as a projectionist by Dynasty. Okay, petitioner filed a complaint for damages with the RTC or trial court because he was dismissed. Okay, now the Dynasty filed a motion to dismiss on the ground that the regular trial court has no jurisdiction because it arose from employer-employee relations. So the case was dismissed. Okay, when this case was filed, the applicable law was Presidential Decree number 1367. However, the amendatory provisions of PD 1691 took effect during the pendency of the case. So it ousted the respondent court of jurisdiction it initially had under Presidential Decree number 1367. Now the question is whether or not Presidential Decree 1691 has retroactive application. Remember that it took effect during the pendency of the case. The case is already filed and is already being heard. Can you still make it apply to the pending case? Okay, the Supreme Court said PD 1691 is a curative statute which corrected the lack of jurisdiction of the labor arbiter at the start of the proceedings and therefore should have been given retrospective application. It was intended to correct a situation where two tribunals would have jurisdiction over separate issues arising from the same labor conflict. So it ousted the regular trial court of jurisdiction and vested the labor arbiter with jurisdiction over the case. It must be noted that the amendatory provision of PD 1367 itself was given retroactive application for also being curative. So it is intended to correct or cure a defect in previous legislation. Okay. So the case of Superiora Local versus Republic is also an exception to the prospective application of laws. Why? Because the statute, okay, which was given retroactive application, created new rights. So if it creates new rights, unless of course it is prejudicial to the rights of another which has already vested, okay, then it can be given retroactive application. So in this case, superiora local filed an application for registration of a land. Okay, previously it was dismissed. So it was denied. Okay, then they filed another application. At this time, RA 1157 has already taken effect at the time of the second application. Now, at the time of the second application, RA number 11570 provided for a lower length of possession, which is 20 years, immediately preceding the filing of the application. Before, in the earlier law, section 14.1 of PD 1529, the requirement is 30 years. Now, RA 11573 lowered it to 20. Now, the question is, can the new law be applied retroactively to the case of Superiora? RA number 11573 does not provide for its retroactive application. While as a rule, laws shall have no retroactive effect. There are a few exceptions, such as when the statute is curative or remedial, or when it creates new rights. So in RA 11573, the law's objective is to simplify, update, and harmonize similar and related provisions of land laws in order to simplify and remove ambiguity in its interpretation and implementation. Curative statutes are intended to correct defects, abridge superfluities in existing laws, and curb certain periods. They're intended to enable persons to carry into effect that which they have designed and intended but has failed of expected legal consequence. Their purpose is to give validity to acts done that would have been invalid under existing laws as if existing laws have been complied with. A curative statute has a retrospective application to a pending proceeding. So in this case, RA number 11573 intended to correct defects and abridge superfluities in our present land registration laws. To be sure, RA 11573 makes valid that which before the enactment of the statute was invalid because the applicant can now prove possession under a bona fide claim of ownership for only 20 years. Okay? Okay. Article 5, acts executed against the provisions of mandatory or prohibitory laws shall be void except when the law itself authorizes their validity. Okay, so Article 5 refers to mandatory or prohibitory laws as opposed from those which are merely permissive or directive. So what do you mean when you say mandatory? It means that there is a positive doing of an act, while prohibitory when something should not be done. Negative. Okay. Let us now go to waiver of rights. Okay. Article 6 states that rights may be waived unless the waiver is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. As you all know, laws are source of rights. Okay, the sources of obligations are also sources of rights. What again are the sources of obligations? We have the laws, okay? We have delicts, quasi-delicts, contracts, quasi-contracts. These sources of obligations are sources also of rights. Now, if you have rights, can you waive it? The answer is yes. What is a right? And as a rule, demandable of another person. It involves two subjects. The active subject, meaning the person entitled to demand the right, and a passive subject, the person who is obliged to suffer the enforcement of the right. Okay. Rights may be waived according to Article 6. However, there are certain rules for the waiver. Okay. First, the right must belong to you. Okay. Because you cannot give or you cannot waive for that matter what you do not have. Okay. Second, the waiver must be expressed, meaning there is an express declaration that you are waiving the right, or implied. Okay. When it is implied, okay, there must be an act, an overt act, which um states or which impliedly, okay, states that you are waiving that right. And there are certain formalities that has to be done before the right is waived. The formalities must be observed. And the last requirement is that the waiver must not be contrary to law, morals, good customs, or prejudicial to a third person with the right recognized by law. Okay? If you are waiving something and that waiver is contrary to law, okay, that right would not that waiver of right would not be valid. So an example, you have the right to make use of your kidneys, right? And if you decide to waive the right to use one of your kidneys by by donating it, okay, for a consideration, that would not be a valid waiver of right. Why? Because it is contrary to law. Okay? So the waiver to be valid must comply with certain conditions. Okay. There are, however, certain rights that cannot be waived. One of which is the right to life. Okay? Inchoate rights, those which have not yet ripened into a full right. Okay? Right to future support. And if the waiver is prejudicial to the rights of a third person with a right recognized by law. Okay. The case of Brazil versus education STI. So this right in this case involves certain professors teaching in STI. Now, there is a requirement of CHED that professors, college professors teaching in tertiary schools should have a master's degree. Okay, now these professors did not fulfill that requirement, but they have been teaching in the school for so long that they are invoking that in the CBA provision, they had already attained regular status as professors, as employees, teachers of STI. Now the question is, can the school waive the requirement regarding the uh, regarding the masteral education required of professors in tertiary schools? The Supreme Court said that it is not a valid waiver. Why? Because first, you would be violating the law, which is a CHED regulation. Second, the school has no right to waive that provision. Why? Because it would be prejudicial to the rights of third persons with a right recognized by law. And who are those third persons? The students. Okay? Because these students have a right to be taught by competent and qualified professors. Okay? So the Supreme Court, speaking in the language of the High Court, the parties are both in violation of the law. Respondents for maintaining professors without the mandated masteral degrees, and for petitioners agreeing to be employed despite knowledge of their lack of qualifications. Petitioners cannot insist to be employed by UST since they still do not possess the required master's degree. The fact that UST continues to hire and maintain professors without the necessary master's degrees is not a ground for claiming illegal dismissal. It cannot be said either that by agreeing to the tenure by default provision in the CBA, respondents are deemed to be in estoppel or have waived the application of the requirement. Such a waiver is precisely contrary to law. A waiver would prejudice the rights of students and the public who have a right to expect that UST provides quality education by hiring only qualified teaching personnel. So this case is an illustration of an invalid waiver. Okay? The case of De La Rosa, Liner versus Borrella. Okay? This is also an illustration of a waiver of benefits which is contrary to law. So in this case, they entered into a compromise agreement. Okay? But the compromise agreement had been concluded to terminate the illegal dismissal and unfair labor case then pending before the CA. So the Supreme Court said that this coverage is too sweeping and effectively excludes any claims by the respondents against the petitioners, including those that by law and jurisprudence cannot be waived without appropriate consideration, such as non-payment of underpay or underpayment of overtime pay and wages. So there are certain labor standards that were waived by the workers in the compromise agreement, such as those overtime pay and wages. So that waiver is not valid. Why? Because it is contrary to law. While rights may be waived, the waiver must not be contrary to law, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. Respondents' claim for 13th month pay, overtime pay, and statutory wages cannot simply be generally waived as they are granted for workers' protection and welfare. It takes more than a general waiver to give up workers' rights to these legal entitlements. The next case is also an illustration of a waiver which is contrary to law. Okay, this case involves a foreclosure of mortgage. In foreclosure of mortgage, there is a need for publication. Okay, in order to inform the public that a certain property is being held up for auction. Now, can you waive that publication requirement? Now, the answer is no. Failure to publish the notice of sale constitutes a jurisdictional defect which invalidates the sale. Petitioner and respondents have absolutely no right to waive the posting and publication required. Notices are given to secure bidders and to prevent a sacrifice of the property. Clearly, the statutory requirements of posting and publication are mandated not for the mortgager's benefit, but for the public or third person. So it is a waiver which is contrary to law as well as the rights of third persons with the right recognized by law. Okay? The next case is a waiver also which is contrary to law. Okay. Remember that when you institute a criminal case, you also file with the criminal case the civil aspect of the criminal case. Now, the question in the salya is that, can you waive both? Meaning, can you enter into an agreement, the accused and the complainant, can they enter into agreement waiving not only the civil aspect of the case, but also the criminal aspect? The answer is no. You can only enter into an agreement relative to the civil aspect of the case, but the criminal aspect could not be waived. Okay? So, There is no law which prohibits a person who has incurred damages by reason of the act of another from waiving whatever rights he may have against the latter. If the act causing damage to another also constitutes a crime, the civil liability arising from the criminal act may be validly waived. What is not allowed is to compromise or to waive the criminal aspect of a case. Those rights which may be waived are personal, while those rights which may not be waived involve public interest. Okay? In a compromise or a waiver of the civil aspect of the case, the restriction imposed by law is that it must be entered into before or during a litigation. Okay, so you cannot compromise the criminal aspect. Okay, why? Because it is contrary to law and only the state or the people can waive it. It is not within your right. You can only enter into an agreement with respect to the civil aspect of the case. Okay. We have talked so much about the effectivity of laws, okay? The right to waive certain rights, okay? And now we go to repeal of laws. In other words, uh, what constitutes repeal of laws? When a law is repealed, it ceases its effectivity. Okay, it is the end of its effectivity. It's the death of the law. Okay, can laws um, be repealed impliedly, or do they need to always be expressed in the repealing law itself? Okay, Article 7 of the Civil Code tells us laws are repealed only by subsequent ones, and their violation or non-observance shall not be excused by disuse, custom, or practice to the contrary. Okay, remember, laws are repealed only by subsequent. So if another law is enacted expressly stating that this law repeals the past law, that is an express repeal, and therefore that past law is repealed. What if there is a subsequent law which, although it did not state that this expressly repeals the past law on the same subject, it nevertheless has provisions which is antithetical or very antagonistic or 360-degree opposed to the past law? Then that constitutes an implied repeal of the past law. Okay, now, what if, although there is a law, it is not observed? Okay, meaning the people, although they know that there is this law, the practice or custom, okay, is to the contrary. So, like what I've said before, so even if there is a law banning firecrackers during New Year, the practice of the Filipinos is that they resort, or as a custom or a practice, they resort to using firecrackers each New Year. Does it mean that the laws pertaining to the ban on certain types of fireworks is already repealed? The answer is no. Okay, why? Because laws are repealed only by subsequent. Custom or practice to the contrary will not repeal a law. Okay. When the courts declare a law to be inconsistent with the Constitution, the former shall be void and the latter shall govern. Administrative or executive acts, orders, and regulations shall be valid only when they are not contrary to the laws or the Constitution. That is the reason why I asked you before during the recitation, um, do courts have the power or the authority to repeal laws? Okay, of course, the answer is no, because laws are repealed only by subsequent ones. And pursuant to the separation of powers, it is only the Congress which has the power to enact laws and therefore to repeal the previous laws. However, the courts have the authority to determine if a certain law is not consistent with the Constitution. Why? Because the Constitution, pursuant to the hierarchy of laws, is the highest law of the land, to which all laws must conform. So in the exercise of their power of judicial review, the courts are with authority to determine if laws are consistent with the Constitution. And if they are not, okay, then they can have it declared as unconstitutional and they will cease to be effective. Okay, so that is also a way of uh, not repealing laws, but declaring a law or a portion of it to be unconstitutional. Because if it is unconstitutional, it ceases to be of any effect. So the effect is the same as that of a repeal of law. Okay, when a law is declared to be unconstitutional, it ceases to become effective. Okay. Now, what are the kinds of repeals? As I was saying a while ago, they are express repeals and implied repeals. Express repeals, they are specifically mentioned in the subsequent law, while implied repeals, there is a repugnancy, inconsistency between the prior and the subsequent law. But in many cases that we will soon discuss, implied repeals are not favored. Why? Because you have to demonstrate the repugnance between the two. And if there is an interpretation that could harmonize the two laws, then that interpretation will be upheld because implied repeals are not favored. Okay? The case of Recana versus Court of Appeals. So in the issue in this case is whether or not Republic Act 1597, an earlier and special law, is already repealed by a later and general law, PD 464. The court ruled in the negative, and neither is there implied repeal, as this kind of repeal is not favored. There is no irreconcilable inconsistency in the terms of the new and the old law. A special statute provided for a particular case is not repealed by a subsequent statute, general in its terms, unless the intent to repeal or alter is manifest, although the terms of the general law are broad enough to include the cases embraced in the special law. Again, the Supreme Court reiterated repeal of law should be made clear and express. Repeals by implication are not favored as laws are presumed to be passed with deliberation and full knowledge of all the laws existing on the subject. Such repeals are not favored, for a law cannot be deemed repealed unless it is clearly manifest that Congress so intended. The failure to add a specific repealing clause indicates that the intent was not to repeal any existing law unless an irreconcilable inconsistency and repugnancy exists in the terms of the new and the old laws. So we find no inconsistency between Section 4 of RA 1597 and Section 78 of PD 464. The former law is special and exclusive application to the lots acquired from Tondo foreshore land only. The latter is a law of general application. So again, the presumption is when Congress enacts a law, okay, it is presumed that they did so with knowledge of the previous laws on the subject. So if their intention is really to amend to amend, to repeal a previous law, then they should have provided it expressly in the present law. Okay, if there is no specific provision in the present law, and there is no irreconcilable inconsistency in the or repugnancy between the old and the new law, then they would not constitute an implied repeal, and an interpretation will be made reconciling the old and the new law. Okay. Next case, LLDA versus Court of Appeal. Okay. Again, it is a reiteration of the previous case. So whether or not Republic Act 7150-60, which is the local government code, repealed RA 4850, granting LLDA the authority to issue water rights over the Laguna de Bay. So the provisions of the local government code do not necessarily repeal the law creating the LLDA. The LLDA does not contain any express provision which expressly repealed the charter of the authority, the local government code rather. It has to be considered that there was no intent to repeal RA 4850 because the repeal of laws should be made clear and express. The Charter of LLDA constitutes a special law. The local government code is a general law. When there is a conflict between a general law and a special statute, the special statute should prevail, since it evinces the legislative intent more clearly than the general statute. The special law is to be taken as an exception to the general law in the absence of special circumstances forcing a contrary conclusion. This is because, again, implied repeals are not favored. Special law cannot be repealed, amended, or altered by a subsequent general law. Okay. The next case is Reyes versus Garilao. The issue in this case is whether or not RA 6675 repealed LOI 474. Again, the Supreme Court reiterated that repeal by implication proceeds on the premise that where a statute of a later date clearly reveals the intention of Congress to abrogate a prior act on the subject, that intention must be given effect. There are two kinds of repeal. The first is where the provisions in the two acts on the same subject matter are irreconcilably contradictory. The latter act, to the extent of the conflict, constitutes implied repeal. The second is if the later act covers the whole subject of the earlier one and is clearly intended as a substitute. It will operate to repeal the earlier law. Okay, the Supreme Court continued or came to the conclusion that it disagrees with the theory that RA 6657 impliedly repealed LOI 474. RA 6657 is a social justice and poverty alleviation program which seeks to empower the lives of agrarian reform beneficiaries through the equitable distribution of lands. On the other hand, LOI 474 imposes restrictive conditions on the exercise of the right of retention by mandating that landowners who possess other lands used for residential, commercial, industrial, or other urban purposes from which they derive income are disqualified from exercising their right of retention. So in other words, both laws are not repugnant to each other, that they can both be given effect. Okay? The special act and the general law must stand together, one as the law of the particular subject and the other as the law of the general application. While RA 6675 is the law of the general application, LOI 474 may still be applied Landowners under 6675 are entitled to retain 5 hectares. However, if they also own other lands for residential, from which they derive income, they are disqualified from exercising their right of retention. Okay? Now we go to the hierarchy of laws. Okay? As you all know, okay, the highest law of the land is the Constitution. The framers of the Constitution are the people of the Philippines. They are the ones who enacted the Constitution. And having been enacted by the people, the Constitution is the supreme law to which all laws must conform. Okay, anything which do not conform to the Constitution must be struck down for being unconstitutional. Okay? The second in the hierarchy are the laws, statutes, and presidential decrees. Ito yung mga Republic Act, okay, Batas Pambansa, presidential decrees. Okay? Third in the hierarchy is administrative or executive issues. Executive orders, okay, and administrative issues. Okay? And then the last one in the hierarchy are orders and regulations. The regulations from the bureaus like the BIR, customs, okay, immigration, okay, they are fourth in the hierarchy. Okay. The constitutionality of a law or executive order may be collaterally attacked. They shall be deemed valid unless declared null and void by a competent court. However, even if a law is later declared as unconstitutional, okay, because as a general rule, okay, if a law is declared unconstitutional, it ceases to become effective, right? Produces no force and effect because it is void. However, there are certain instances when, okay, even if a law is ultimately declared as unconstitutional, it may produce certain effects under the doctrine of operative facts, okay, which we will discuss subsequently in the next cases. Okay, the case of LLPA versus COA. So to rationalize the compensation of government employees, the Congress enacted Republic Act 6758, Compensation and Possession Classification. Now, a subsequent statute, generally in character as to its terms and applications, is not to be construed as repealing a specific enactment unless Congress intended it to do so. So in order to achieve the purpose of 6758, repeal of the corporate charter of the petitioner becomes imperative. Again, our rules on statutory construction provide that a special law cannot be repealed, amended, or altered by a subsequent general law. A statute, general in character, is not to be construed as repealing a special enactment unless unless a contrary intention by Congress is manifested. So in this case, the ITC should now be considered as covered by laws prescribing a compensation and position classification in the government, including 6758. So with the repeal of its corporate charter, which excludes from its coverage RA 6758, the disallowance of the fringe benefits finds support under Section 12 of RA 6758. Clearly, the COA acted in contemplation of the law when it correctly applied RA 6758, disallowing the subject benefits. Okay, so the next case is People versus Mateo. Did RA 10951 repeal by implication, PD 1618. So in this case, Mateo was found guilty of syndicated estafa. During the pendency of the case, RA 10951 was passed with the primary objective of adjusting the amounts of the values of the property and damage on which a penalty is based for various crimes committed under the revised penal code, including estafa. Now, did that law, okay, repeal by implication, PD 1689? It should be considered that PD 1689 is a special law which was enacted for the purpose of defining syndicated estafa and imposing a specific penalty for the commission of the said offense. So from the provisions of RA 10951, there appears no manifest intent to repeal or alter the penalty for syndicated estafa. If there was that intent, then the amending law should have clearly indicated, because implied repeals are not favored. A special law cannot be repealed, amended, or altered by a subsequent general law by mere implication. So absent an express repeal, a subsequent law cannot be construed as repealing a prior one unless there is an irreconcilable inconsistency. The court finds neither inconsistency nor incompatibility in the provisions of 1689 and RA 10951. Okay. CIR versus San Roque Tower speaks of the doctrine of operative. Okay, although a certain law is declared void because it is repugnant to the Constitution, okay, or the law which is it is supposed to implement, it can produce certain effects under the doctrine of operative acts. The general rule is that a void law or administrative act cannot be the source of legal rights or duties. However, the doctrine of operative facts is an exception to the general rule, such that a judicial declaration of invalidity may not necessarily obliterate all the effects and consequences of a void act prior to such declaration. The Constitution being supreme and paramount, any legislative or executive act contrary to its terms cannot survive. Okay? It does not admit of doubt that prior to the declaration of nullity, such challenged legislative or executive act must have been enforced and had to be complied with. This is so until after the judiciary declares its invalidity. It is entitled to obedience and respect. Parties may have acted and may have changed their positions. It is now accepted as a doctrine that prior to its being nullified, its existence as a fact must be reckoned with. Precisely because the judiciary is the government organ which has the final say on whether or not legislative or executive measures is valid. For the operative fact doctrine to apply, there must be a legislative or executive measure, meaning a law or executive issuance, that is invalidated by the court. From the passage of the law or promulgation of the executive issuance until its invalidation by the court, the effects of the law or executive issuance, when relied upon by the public in good faith, may have to be recognized as valid. It is also consistent with the pronouncement that judicial decisions are to be applied prospectively. Okay? Article 8. Now go to judicial decision. So we're now through with laws. Let us now go to jurisprudence. Article 8 states that judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system of the Philippines. Okay, remember, judicial decisions are not laws. However, even if they are not laws, they are the evidence or the interpretation of what the laws. Okay? And being the interpretation of the laws, they have the force of. Okay? The decisions referred to, however, when we say judicial decisions, apply to the decisions issued or promulgated by the Supreme Court. Decisions of subordinate courts like the Court of Appeals, the regional trial courts do not have, uh, are not considered as having the force of law. Why? Because they are only persuasive in nature. Okay? What is the doctrine of stare decisis, the legal principle? The doctrine of adherence to precedent means that once a case has been decided one way, another case involving exactly the same point in issue should be decided in the same manner. However, it does not mean that judicial decisions are cast in stone. Okay? It may be abandoned by a contrary ruling by the Supreme Court if there is a conflict between the precedent and the law. The case of heirs of Gamboa versus Tebes. Okay? It also reiterates my earlier or our earlier discussion that judicial decisions that are also applied prospectively. Okay? It has been the constant holding of the court that a judicial decision setting a new doctrine or principle shall not retroactively apply to parties who rely in good faith on the principles and doctrines standing prior to its promulgation, especially when a retroactive application of the precedent setting decision would impair the rights and obligations of the parties. So the principle of prospectivity has also been applied to judicial decisions. The new doctrines and principles must be applied only to acts and events transpiring after the precedent setting judicial decision, and not to those that occurred and were caused by persons who relied on the old doctrine and acted on the faith thereof. Okay, the case of De La Cruz versus Ochoa uh, illustrates to us or defines for us the doctrine of stare decisis. Okay, to adhere to precedents and not to unsettle things which are established. Under the doctrine, when this court has once laid down a principle of law as applicable to a certain state of facts, it will adhere to that principle and apply it to all future cases where facts are substantially the same, regardless of whether the properties and property are the same. The doctrine of stare decisis is one of policy, grounded on the necessity for securing certainty and stability of judicial decisions. Stand by the decision and disturb not what is settled. Stare decisis simply means that for the sake of certainty, a conclusion reached in one case should be applied to those that follow, if the facts are substantially the same, even though the parties may be different. Like cases ought to be decided alike. That is, in gist, what stare decisis is all about. Okay? Similar cases should be decided in a similar way. Okay? You cannot say, if the facts are substantially the same, that in the first case, your ruling is this way. And then, but in another case, you are 360 degrees to your previous ruling. Why? Because if they have the same facts, okay, the ruling should also be similar or uniform. Okay, applying the doctrine of stare decisis. But that does not mean that the Supreme Court is not at the liberty to abandon a settled doctrine if, in their opinion, that doctrine should already be abandoned. But if there is a new doctrine, okay, that should be applied prospectively, meaning to those cases that uh, will be filed, but not to those cases which were already decided under the old doctrine. Okay, Transco versus Orobil is again a reiteration of the, the doctrine of stare decisis. This is a case involving expropriation. The facts of this case are substantially the same with Texon and similar cases. A government agency took possession of private property for the benefit of the public without initiating expropriation proceedings, which constrained the landowner to file actions to recover their properties and to demand payment of just compensation. In the absence of any compelling reason to deviate from the rulings in the previous cases, the court must adhere to the doctrines established there. Okay. However, the rule requiring the application of the same doctrine to a case which has substantially similar facts as that of a previous case does not apply to obiter dictum. Okay? It only applies to the main doctrine but not to an obiter dictum. What is an obiter dictum? This is defined in the case of Ocean East Agency versus Lopez. An obiter dictum has been defined as an opinion expressed by a court upon a question of law that is not necessary in the determination of the case before the court. It is a remark or an opinion expressed by a judge in his decision and not directly upon the question before him. So it lacks the force of an adjudication, being a mere expression of an opinion with no binding force for purposes of res judicata. Okay? So, an obiter dictum is an aside. It does not directly deal with the main issue in the case. Okay? So, the doctrine of stare decisis applies only to the main doctrine. Okay? That which has a bearing directly on the issue which is involved in the case. Okay? Silence, obscurity, or insufficiency in the what happens if in a particular case, it seems that there is no applicable law. Okay? The law seems to be silent or there was insufficient in what is provided under the law. Can the judge simply refuse to decide on the case because there is no applicable law? Article 9 states that no judge or court shall decline to render judgment by reason of silence, obscurity, or insufficiency of the law. The duty of the judge is to render a decision whether he knows what law to apply or not. Okay, I encountered this particular situation when I was deciding the case of People versus Terrio, where Mary Jane Veloso is the private complainant. So in that case, it seems that there is insufficiency in our criminal laws because our criminal laws require that the accused should have the right to confront the witnesses against him. However, considering that Mary Jane Veloso is in death row and is in prison in Indonesia, that particular provision or right of the accused cannot be simply enforced. Okay, our civil procedure provides for taking of testimony through deposition. Deposition through the written interrogatories. Okay, so meaning there is no face-to-face confrontation by the accused, but the prosecution and the defense will simply propound questions to the complainant who is imprisoned in Indonesia through written questions that will be uh, asked upon her. Okay. However, our laws on criminal procedure do not have a similar provision regarding depositions through written interrogatories. Would it violate the right of the accused to confront the witnesses against him when he is only represented by counsel and he cannot be physically present when those questions are propounded to the complainant? So I decided the case in such a way that even though uh, our laws on criminal procedure do not have that provision on taking of testimonies through depositions upon written interrogatories, I said that that can be applied suppletory to our rules on criminal procedure. I was reversed by the Court of Appeals when that case was elevated to them, to the CA. But then the Office of the Solicitor General elevated it even to the Supreme Court. And I was sustained by the High Court saying that indeed, even though the rules of criminal procedure do not allow such taking of depositions through written interrogatories, considering that there is a vacuum in our laws on criminal procedure, the court held that the provisions of civil procedure can be applied in a supplemental manner to our criminal procedure. And the Supreme Court even directed the Committee on Rules to formulate rules on future cases involving similar nature. Those cases of similar nature in the future. Okay? So, what happens if there is a doubt in the interpretation of the law? In case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. So in case of doubt, the judge should presume that Congress intended right and justice to prevail. Of course, there are rules on statutory construction. I leave it to Attorney Kingston to discuss the rules on statutory construction. Okay? Then we go to customs. Okay? Can customs be a source of rights? Customs which are contrary to law, public order, or public policy shall not be counted. A custom may be proved as a fact according to the rules of evidence. Okay? Can customs be a source of rights? The answer is yes. Okay? Provided that the custom is not contrary to law, public order, or public policy. Okay? A custom may be proved as a fact according to the rules of evidence. The difference, however, between customs and laws is that a law, you can directly invoke it as a source of right. However, for you to invoke custom as a source of right, you must prove it as a fact. Okay. What are the requirements before it can be considered as a custom? Okay. First, it must consist of repeated acts, meaning it is repeated over time. There is sufficient lapse of time. It is a rule of social conduct. And it must not, of course, be contrary to law, public order, or public policy and morals. Okay? And it must also be proved as a fact. T versus Gonzalez teaches us that customs must be proved as a fact. To establish a valid foreign marriage, two things must be proven. The existence of the foreign law as a question of fact, and the alleged foreign marriage by convincing evidence. Because in that case, the issue is made the testimonies of witnesses as to the custom of marriage in China be sufficient evidence on the validity of said marriage. Okay? Now, in that case, the Supreme Court defined what custom is. It is a rule of conduct formed by repetition of acts, uniformly observed as a social rule, legally binding and obligatory. The law requires that a custom must be proved as a fact according to the rules of evidence. A local custom as a source of right cannot be considered by a court of justice unless such custom is properly established by competent evidence like any other fact. That is the main difference between custom and law as a source of right. Okay, in law, you have it documented. In custom, you have to establish it as a matter of fact. Okay, complying with the rules of evidence. So in this case, petitioners did not present any competent evidence relative to the law and custom of China on marriage. There is no showing that they are competent to testify on the matter. For failure to prove the foreign law, the validity of the marriage in accordance with said law or custom, the marriage cannot be recognized in this jurisdiction. Okay, Pantaleon versus Amex. Is custom a source of legally demandable and enforceable right? In this case, the court answered it in the negative. Why? Because they failed to establish the repeated acts, okay, that transpired over time. Okay, because this case involves an issue on whether the purchase request, the time which is the time which elapsed for acting on purchase request can be considered as a legally demandable right. As a general rule, a practice or custom is not a source of legally demandable or enforceable right. There is no provision in this agreement that obligates Amex to act on all cardholder purchase requests within a specifically defined period of time. So they are talking about the membership agreement. Okay, so if you're talking about the agreement, okay, there is no legally demandable and enforceable right, which will force Amex to act on purchase requests within a certain period of time. Okay, however, if you are able to prove, okay, that there is a certain custom, okay, which is proved by repeated acts as well as the period of time which was observed, then it can be a source of a legally demandable and enforceable right. Okay. So the case of Home Credit Mutual Building and Loan Association states that in labor cases, benefits which were voluntarily given by the employer and which have ripened into a company practice are considered as rights and are subject to the non-diminution rule. However, the burden to establish that the benefit has ripened into a company practice rests with the employee. So it is incumbent upon the employee to prove that the giving of the benefit has ripened into a company practice. Okay. Now let us go to computation of periods. This is very basic. That when the law speaks of years, months, day, or nights, It shall be understood that years are 365 days, wala na yung 1/4. Months of 30 days, wala na yung 31 or 28. Days of 24 hours, and nights from sunset to sunrise. Okay, months are designated by name, they shall be computed by the number of days which they respectively have. In computing a period, the first day shall be excluded and the last day included. Okay, so if for example you are given 10 days from today, today is, let us say, September 14. How do you count 10 days? Okay, do you start from today or do you start tomorrow? Person 1 to Article 13. First day excluded, last day included. So today is September 14. You don't begin counting today. You begin counting tomorrow. So 15, 16, 17, 18, 19, 20, 21, 22, 23, 24. So September 24 will be your last day. However, September 24 fell on a Sunday. Okay? When should the last day be? Is it September 24, which fell on a Sunday? The answer is no. Okay? The last day will fall on the next working day, which is Monday, September 25. That is the doctrine in the case of Rainier Pacific versus Guevara. Okay, what if there is a motion for extension of time? Okay, so our last day is September 24, 10 days on. What if the council filed a motion for extension of time on September 22? Okay, when should the 10-day extended period be counted? Okay, is it from September 25, which is supposed to be the last day, or should it be on the original period, which is due to expire on the 24th? The answer is you begin counting the extended period on the original period. So that is September 24, 25, 26, 27, 28, 29, 30, 1, 2, 3. So the new due date, the new extended due date is October 3. Okay? So that is basically easy. NACTOR versus IAC, it's the same as Rainier Pacific. Okay? So we now begin to the basic legal principles. Okay? Let us begin with the territoriality and generality principles. Under Article 14, penal laws and those of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations. So what do you mean by territoriality? Okay. Territoriality means that any offense committed within our territory offends the state. Thus, any person, whether a citizen or an alien, can be punished for committing a crime here. So you must remember that with respect to penal laws, criminal laws, the important thing to consider is where the offense was committed. If the offense was committed in the Philippines, regardless of who you are, okay, you are to be held liable in the Philippines. Okay. That is what is also meant by generality. Even aliens come under our territorial jurisdiction because aliens owe some sort of allegiance, even if it is temporal. So regardless of the person who committed penal or criminal offenses, okay, they are to be held liable in the place where the offense was committed. However, Again, there are certain exceptions under the principles of public international law, such as the immunities granted to visiting heads of state and diplomatic officials while they are performing their official functions, and certain treaty stipulations which we have entered into with other countries. So the case of People versus Tulin, okay, this is the case involving piracy. Okay, piracy is a continuing crime, and and considering that it is a reprehensible crime, um, the it is considered as one of the exceptions to the territoriality principle. In this case, the attack and seizure, okay, was committed in Philippine waters. So it started in the Philippine territory. Although the vessel was captured somewhere in Singapore, can the offenders be held liable under Philippine laws, considering that the offense started within the Philippines? The disposition by the pirates of the vessel and its cargo is still deemed part of the act of piracy, hence the same need not be committed in Philippine waters. Regardless of the law penalizing the same, piracy is a reprehensible crime against the whole world. It is considered or held as a continuing offense since one of the elements of the offense happened within the Philippine territory. He can be held liable under the Philippine laws. Okay? The next case is Del Socorro versus Wilson. It is a very interesting case because there seems to be a clash between the territoriality principle and the nationality principle. The nationality principle we will discuss later, but for purposes of discussing this case, the nationality principle means that, okay, laws relating to family rights and duties, the status, condition, and legal capacity of persons, they are governed by the national law of the person. So if you are a Filipino, okay, no matter where you go, whether you are in Switzerland, you're in Kenya, you're in Argentina, your national laws follow you. Okay? With respect to laws relating to family rights and duties, status, condition, legal capacity of person, then it follows you wherever you go. So no matter what state you are in, okay, you are still followed by your national law. So that is the nationality principle. So remember, territoriality and generality principle, they are effective insofar as penal laws are concerned. So what is important is the place where the offense was committed, okay, regardless of the nationality. On the other hand, with respect to the nationality principle, with respect to the laws relating to family rights and duties, status, condition, legal capacity of persons, regardless of what country you are in, your national laws follow. Okay? So let's go back to the case of Del Socorro. So in this case, Del Socorro and Wilson contracted marriage in Poland. Okay, they were married in Poland, and then thereafter they were divorced by Poland. However, the petitioner Del Socorro went back to the Philippines. However, her husband never gave support to the son. So the petitioner filed a case for violation, non-support, violation of Republic Act 9262. Now, the question is whether or not a foreign national can be held criminally liable under Republic Act 9262 for his failure to provide support. Remember, the family rights and duties comprises of who are the persons whom you have a duty to support. Okay? Remember, that is part of nationality principle. So considering that the husband of Del Socorro, Wilson, is a Holland, national of Holland, the laws on Holland, okay, is the law governing the persons whom he is duty bound to support. Okay? Insofar as Philippine laws are concerned, the same only applies to Filipino citizens. But Republic Act number 9262, remember, is a penal law. Okay? So being a penal law, territoriality principles govern. Since the non-support was committed within Philippine laws, isn't it that the territoriality principle should govern in this case? On the other hand, Wilson contends that nationality principle should govern because it's a national of Poland. And the persons who are entitled to be supported by him is determined by Holland. Okay. However, in this case, while Wilson pleaded the loss of the Netherlands, that he is not obliged to support his son, he was never able to prove the loss on Holland. So, because he was not able to prove the loss on Holland, it is presumed that they are the same as Philippine laws. Okay? Uh, and therefore, considering that it is the same as Philippine laws, he will be obliged to provide support to his son. Okay? Foreign law should not be applied when its application also would work injustice to the citizens of the home. So even if the laws of Poland neither enforce a parent's obligation to support his child, such obligation is still duly enforceable in the Philippines because it would be of great injustice to the child to be denied financial support. So we find that the respondent may be made liable under Republic Act 9260. Okay? Considering that respondent is currently living in the Philippines, the petitioners claim that the territoriality principle in criminal law should be applied. Our courts have territorial jurisdiction over the offense against the respondent. Okay, now we go to the nationality principle. Article 15 tells us that laws relating to family rights and duties or to the status, condition, and legal capacity of persons are binding upon citizens of the Philippines even though living abroad. So what is important are the kinds of laws, because these laws follow you no matter where you are, no matter what country or state you are in. Okay, what are these laws? Family rights and duties. What are family rights and duties? Parental authority, marital authority, support. Okay? Status. What do you mean by status? Personal qualities and relation, such as whether you are married or not, whether you are legitimate or illegitimate. Condition as well as legal capacity of persons. The legal capacity to get married, the age, okay, when you're able to enter into contracts, to enter into marriage, these are governed by your national law. Now, citizens of other countries are governed in matters of status by their own respective national laws. Okay. Now, the capacity to enter into ordinary contracts is governed by the national law of the person and not by the law of the place where the contract was entered in. So, in certain countries, the legal age is 21. In the Philippines, it is 18. So what if, let us say in Korea, South Korea, the emancipation age or the age of the legal age in that country is 21. What if a Filipino is only 18 years of age, enters into a contract of sale, for example, in South Korea? Is that considered as valid? The answer is yes. Why? Because in the Philippines, he is already legally capacitated to enter into contracts because he is already of legal age. Okay. Now, let us reverse the situation. What if the South Korean national went to the Philippines? The South Korean national is only 18 years old. The South Korean national entered into a contract of sale here in the Philippines. Is that contract valid? The answer is no. Why? Because in the law of his nationality, the South Korean is still not yet of legal age because the legal age in South Korea is 21. Even if that South Korean national entered into a contract with uh, here in the Philippines on which the legal age is 18, that legal age would not govern him because he is a South Korean national and his national laws follow him wherever he goes. Okay. Suzuki versus OSG. So in this case, petitioner sought to be recognized in there is an adoption decree which is issued in Japan, wherein a Japanese national adopted a Filipino child. Okay. Now, the Filipino child wanted the Philippine courts to recognize the adoption, which was issued in Japan. Now, the RTC dismissed the case on the ground that the court cannot recognize the degree of adoption because uh, it would not recognize the laws of the Philippine courts on adoption. However, according to the Supreme Court, it failed to consider the fact that the adopter is a Japanese citizen. And because the adopter is a Japanese citizen, his laws, okay, will the nationality principle or the laws of Japan on adoption should govern and not Philippine laws. Okay? With respect to Hayashi, who is a Japanese citizen, it bears stressing that Philippine courts are precluded from deciding on his family rights and duties or on his condition and legal capacity concerning the foreign judgment to which he is a party. Thus, as to the foreign judgment of adoption obtained by Hayashi, if it is proven as a fact, the Philippine courts are limited to the determination of whether to extend its effect to the petitioner, the Filipino party. So the case of Keppel versus Keppel. So in this case, the spouses, Angelita and Macaraig, okay, got married in Germany. Okay, they are both German citizens. Now, Angelita filed divorce proceedings against Reynaldo. It was granted. Now, shortly, Angelita and George got married in Germany and they were blessed with a daughter. Now, Angelita filed this case for annulment of marriage on the ground of George's psychological capacity. Now, the Supreme Court said, Angelita, you cannot invoke the family code. Why? Because you are a German national now. And being a German national, your national laws are the ones which are applicable to you. Okay? You cannot invoke the family code. Okay? It was the pertinent German law that governed. Philippine law finds no application as far as the family rights and obligations of the parties who are foreign nationals are concerned. Philippine laws do not provide for absolute divorce and hence the courts cannot grant the same. So the remedy of annulment of marriage due to psychological incapacity afforded by Article 36 is not available to her. Okay, the case of Gaspi versus Trinidad. Okay. The nationality principle is not applied when determining the extrinsic validity of an alien's last will and testament. Remember, to what laws does the nationality principle apply? They apply to laws relating to family rights, status, condition, legal capacity of persons. With respect to those laws, it is the law of your nationality that governs. However, with respect to determining the extrinsic validity of a will, okay, they do not refer to any of those laws. Why? Because extrinsic validity of a last will and testament pertains only to the formalities that are needed for a will to be valid. So in this case, the nationality of the testator would not be essential or important. Okay? It is the place of the execution, the lex loci celebrations, which is important in determining whether or not that will is valid. Okay? When it comes to the probate of an alien's will, whether executed here or abroad, the alien's national law may be pleaded and proved before the probate. Otherwise, Philippine law will govern by default. So in this case, the testator Lipson is an American citizen temporarily residing in Bicol. Now, she executed a last will and testament. However, the RTC dismissed the case on the ground that Lipson was an American citizen. Now, the Supreme Court said the extrinsic validity of the will is governed by the law of the country where the will was executed and presented for probate. So when it comes to the form and solemnities of wills, which are part of its extrinsic validity, the Civil Code provides that the law of the country of execution shall govern. So thus, Philippine law on the formalities of will applies. Okay. So now we go to Article 16. Okay, let's recitate. Real property as well as personal property is subject to the law of the country where it is situated. Okay, lex, law, re, the property, site, situs. Law of the property, law of the property where law of the country or the property where it is situated. However, intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country where said property may be. Okay. So with respect to intrinsic validity of the will, who are the persons that are entitled to succeed you, whether intestate or intestate? Okay? These provisions are not governed by the place where the property is situated. It is governed by the law of your national because they belong to family rights and duties. Example, if for example, you're an American citizen, however, you left properties within the, you executed a will of that property within the Philippines, in the Philippines. Okay. What laws govern, okay, the said property? the property which is within the Philippines. Let's say a condo unit in Manila. What laws will govern it? Is it the American law? Let's say, for example, you are a citizen of the United States, uh, California, for example, and then but you are temporarily in the Philippines, you left properties within the Philippines. With respect to the will, which was executed in the Philippines, covering property in the Philippines, the extrinsic validity of the wills, whether the required formality was observed, is governed by Philippine law. However, who shall succeed, who are entitled to succeed you in that property, that is governed by the U.S. laws, the nationality of the testator. Okay? With respect to whether or not certain persons were uh, preterited or omitted, okay, from the will, that is governed by the American law, the U.S. law, not by Philippine laws, because they refer to the intrinsic validity of the will. Okay? Matters of formalities, they are governed by the law of the place where the property is situated. Matters pertaining to who are entitled to succeed you in the will, amount of successional rights, intrinsic validity of the will, these are governed by the laws of your nationality. Okay? What is lex resite? Property, whether real or personal, is governed by the law of the place where the property is situated. Why? Because a contrary rule would render a judgment ineffective or incapable of enforcement. What are the applications of lex resite? If, for example, you have money in the bank, you're a foreigner, you deposited money in a bank in the Philippines, then it can be subjected to tax. Okay? Even though you're a foreigner, because the location of your money is in the Philippines. Shares of stocks owned by a foreigner may be taxed provided it is located in the Philippines. Okay, these are examples of lex resite. What are the exceptions to lex resite? Order of succession, amount of successional rights, intrinsic validity of the will, and capacity to succeed. Okay, why? Because these are governed by your national laws. Okay. Then we will encounter in the succeeding cases a renvoi problem. What is renvoi? It means to refer back. If one state follows the nationality theory and the other, the domiciliary theory, there is a possibility that the problem may be referred back to the law of the first state. Okay. For example, if a person is, let's say, an American citizen, okay, so he is a national of America, but he resides in the Philippines. Okay, there might be a situation wherein, because the law of the Philippines follows the nationality principle. So, for example, if he left a will and he has a family in the US and a family in the Philippines, okay, according to the laws in the Philippines, okay, it is the national law of that American citizen which will govern. But if in accordance with the laws of the US, it is the law of his domicile and not the laws of his nationality that will govern. There will be a renvoi. It will be like a football wherein the ball is tossed back and forth to the two different countries. That is what is meant by renvoi. Okay? Orion Savings Bank versus Suzuki. So in this case, Suzuki, a Japanese national, bought a condo unit, okay, from a Korean national. So the property was located in Mandaluyong. However, Kang the Korean failed to execute a deed of sale. Now, of course, Suzuki filed a complaint to compel Kang to execute the deed of sale. However, Orion contended that the deed of sale executed by Kang is null and void because under Korean law, Okay, any conveyance of conjugal property should be made with the consent of both spouses. So it is a principle, universal principle, that real or immovable property is exclusively subject to the laws of the country or state where it is located. Immovables are part of the country and so closely connected to it that all rights over them have their natural center of gravity here. An instrument will be ineffective to transfer title to land if the person making it is incapacitated by the lex loci res ipei, even though under the law of his domicile, it, his capacity is undoubted. Matters containing the title and disposition of real property shall be governed by Philippine law, while issues pertaining to the conjugal nature of the property shall be governed by South Korean law. Okay, so insofar as that property is concerned, concerning that it is within the Philippines, if Kang is legally capacitated, he is already of legal age to enter into contract, then that law will govern. But on determining whether or not the said property is conjugal in nature, that is something which should be governed by South Korean law. Okay, however, considering that Kang failed to prove the pertinent South Korean law, then the processual presumption will apply. Okay, Llorente versus TA. So in this case, Lorenzo first married petitioner Paula. Lorenzo Llorente is a U.S. citizen. Okay, he first married Paula. However, they subsequently got divorced. Then subsequently, Lorenzo married Alicia. Lorenzo executed a last will, bequeathing all his property to his second wife, Alicia, and to their 3 children. Now, the trial court denied Alicia's petition and ruled that the divorce decree granted to Llorente was void and inapplicable in the Philippines. So the CA called to the fore the Renboa doctrine, where the case was referred back to the law of the decedent's domicile. In this case, the Philippine law. American law follows the domiciliary theory, hence Philippine law applies when determining the validity of Lorenzo's will. Okay, the Supreme Court said that there is no such thing as one American law because they consist of different states. Each state has its own law applicable to its citizens. It can therefore refer to no other law than the law of the state in which the decedent was a resident. Okay, we stated that the divorce and its legal effects may be recognized by the Philippines insofar as respondent is concerned in view of the nationality principle. For failing to apply these doctrines, the decision of the CA must be reversed. So the clear intent of Lorenzo to bequeath his property to his second wife is shown. We do not wish to frustrate his wishes since he was a foreigner not covered by our laws on family rights and duties. Whether the will is intrinsically valid and who shall inherit from Lorenzo are issues best proved by the foreign law, which must be pleaded and proved. Whatever public policy or good customs may be involved in our system of legitimes, Congress did not intend to extend the same to the succession of foreign nations. The case of Bellis versus Bellis. In this case, Amor Bellis executed a will in the Philippines. He died in Texas. He was a resident of Texas. His will was admitted to probate in the CFI of Manila. Okay, so we have here a case wherein Bellis is a citizen of the U.S. and he is also a resident of Texas, USA. He left a will of a property that he had in the Philippines and it was admitted to probate in the CFI of Manila. Now, there was a question considering that certain illegitimate children are complaining that they are deprived of their legitimate. So, is the Renwa doctrine applicable in this case? The Supreme Court said no, because the Renwa applies only if one is a resident and a domicile of one country and a national of another country. So said doctrine is usually pertinent where the decedent is a national of one country and a domicile of another. So in the present case, it is not disputed that the decedent was both a national of Texas and a domicile thereof at the time of his death. So that even assuming that Texas has a conflict of law, providing that the domiciliary system should govern, the same would not result in a reference back already to Philippine law, but would still refer to Texas law. Okay? In this case, in the matter of the testate estate of Edward Christensen, the Renwa doctrine was applied. In this case, Christensen is an American citizen domiciled in the Philippines. So he left a will. However, Helen opposed the same because it deprived her of her legitimate. Okay, now the court below, the trial court, said that Christensen was a U.S. citizen at the time of his death. Therefore, successional rights and intrinsic validity of the will are governed by the laws of California. However, the laws of California state that there are two sets of law, one for residents and another for those domiciled in other jurisdictions. So, the laws of California state that, okay, it is the laws of the domicile that should govern. Okay, so the conflict of law rule in California precisely refers back the case when a decedent is not domiciled in California to the law of his domicile, the Philippines. So the court of domicile cannot and should not refer back the case to California. Such an action would leave the issue incapable of determination because the case will then be like a football, tossed back and forth between the two states. The Philippine court must apply its own law as directed in the conflict of law if the question has to be decided, especially as the application of the internal law of California provides no legitimate for children, while the Philippine law makes natural children legally acknowledged first heirs of the parent recognizing them. Okay, we now go to Article 17, Lex Loci Celebrationis, okay, or the law of the place of the celebration. Okay, so Article 17 states that the forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, the solemnities established by Philippine law shall be observed. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgments promulgated or by determinations or conventions agreed upon in a foreign country. Okay, what is the doctrine of Lex Loci Celebrationis? The said doctrine governs the extrinsic validity, forms, and solemnities of contracts, wills, and other public instruments. A contract entered into by a Filipino in Japan will be governed by Japanese law insofar as forms and solemnities of the contract is concerned. Example, okay, contracts involving sales of real property. In the Philippines, it is required that sales of real property should be in written form, in writing. Okay. If you are in the Philippines, Okay, you're required to conform or comply with that court. But if you are in Japan, in another country, for example, where even an oral sale of real property can be recognized, okay, that specific uh, rule need not be followed if you are executing that sale in that other country where the written form is not required. Okay, so in other words, with respect to forms and solemnities of contracts, wills, and other public instruments, you follow the law of the country of where they are executed. Okay? Continental Micronesia versus Baso. So in this case, there is a contract, okay, that was entered into uh, between an American company and Baso. Okay, what is the applicable law? Is it the US law or the Philippine law? In this case, the Supreme Court said that the Philippine law is the applicable law. The contract of employment was negotiated in the Philippines. A purely consensual contract, it was also perfected in the Philippines when Baso accepted the terms and conditions of his employment. The place of performance is also the Philippines. The prohibited acts were also committed in the Philippines. We rule that a foreign law, judgment, or contract contrary to a sound and established public policy of the forum shall not be applied. Foreign law should not be applied when its application would work injustice to the citizens or residents of the forum. We have here another case, Hasegawa versus Kitamura. So in this case, Nippon, a Japanese consultancy firm, entered into a contract, an independent contractor agreement with Kitamura, a Japanese national permanently residing in the Philippines. Now, Hasegawa did not automatically renew the said contract. So, Kitamura filed a complaint for specific performance with the RTC. Okay. He asserted that the claim for improper pre-termination could only be heard in the proper courts of Japan, following the place of Lex Locis Celebrationis and Lex Contractus. Lex Locis Celebrationis relates to the law of the place of the ceremony. The doctrine of Lex Contractus means the law of the place where a contract is executed or performed. So under the state of the most significant relationship rule, to ascertain what state law to apply, the court should determine which state has the most substantial connection to the occurrence and the parties. It should consider where the contract was made, was negotiated, was to be performed, and the domicile, place of business, or place of incorporation of the parties. So petitioner's premature invocation of choice of law rules is exposed when they have not yet pointed out any conflict between the laws of Japan and ours. Also, when the law of a foreign country is invoked, it must be pleaded and proved. Since the RTC is vested by law with the power to entertain and hear the civil case, that jurisdiction, the trial, and the appellate courts correctly denied the petitioner's motion to dismiss. So when you are pleading a foreign law, you have to prove it in accordance with the rules of evidence. Okay, we have another interesting case, Ambrose versus Ambrose. So in this case, petitioner Paul Ambrose is a U.S. citizen. Okay, he married Luella, okay, in Manila. Lex Loci Celebraciones, place of celebration of the marriage is Manila. Okay. Paul is an American citizen. Now, petitioner filed a complaint for declaration of marriage under Article 36 of the Family Code. Remember, Paul is a U.S. citizen. He invoked the Family Code. Nationality principle, remember that if you are a citizen of another country, your national laws follow you. Now, of course, the RTC dismissed the petition because Paul is an American citizen and he is not covered by the Family Code. Okay, the marriage between the parties having been celebrated in the Philippines, it is governed by Philippine laws. The same law holds true with its incidents and consequences. Thus, all matters relating to the validity of the contract of marriage, such as the presence or absence of the requisites, forms, or solemnities, are to be judged in relation to the law in which it has been celebrated or performed. So along this line, it is useful to state that when the marriage is celebrated elsewhere, its validity does not depend fully on the foreign law. While accepted in the jurisdiction in which it is celebrated, it may be held invalid in the Philippines when it falls under the instances mentioned in Article 26, such as incestuous, bigamous marriages, as well as, irrespective of the place of solemnization, Philippine laws bind contracting Filipino citizens with respect to family rights and duties, status, condition, and legal capacity. The action relates to the validity of the marriage celebrated in the Philippines. The petitioner's action assails the psychological incapacity of the respondent to perform essential marital obligations. Ultimately, the result of the action would have an effect on the personal status of the respondent. With this, there is no reason to foreclose the petitioner's right to institute the instant petition for nullity of marriage. Remember, here, the wife remained to be a Filipino citizen. Although the one who invoked the Article 36 of the Family Code is the uh, American citizen, invoking the place of celebration of marriage. Okay? The last case is Saudia versus Rebesencio. So in this case, Saudi hired the respondents as cabin attendants, but they were separated on the ground that they became pregnant. Thus, they filed a complaint against Saudi for illegal dismissal. Now, Saudi questioned the jurisdiction of the labor arbiter. The issue now is whether the labor arbiter and the NLRC may exercise jurisdiction over Saudi and apply Philippine laws in the dispute. In the resolution of the case, the Supreme Court discussed several doctrines, several principles in conflicts of law, referring to forum non-convenience. Okay, but in the end, the Supreme Court said that while a Philippine tribunal is called upon to respect a party's choice of governing law, such respect must be so permissive as to lose sight of considerations of law, morals, good customs, public order, or public policy. Measures that discriminate on the basis of one's being male or female, it imposes an obligation to actively engage in securing the fundamental equality of women and men. So Dia's policy excludes from and restricts employment on the basis of no other consideration but sex. It would be the height of inequity to view pregnancy as a disability so permanent and immutable that it must entail the termination of one's employment. So we fail to appreciate how pregnancy could be such an impairing occurrence that it leads to other recourse but a complete termination of the means through which a woman earns a living. Philippine laws properly find application and govern this case. It follows that Philippine tribunals may properly assume jurisdiction over the present controversy. So that's it for today. Thanks for listening.